it's interesting. The law specifically states that this is just a transitional law. And what the legislators intend to do is, the reason it got passed and it had to have the language that it's just transitional is because the legislative session was coming to an end. Mm-hmm. It ended August 31st. And by the California Constitution, they had to have any bills that they wanted signed by the governor on his desk by September 1st. The way you said it is perfect. We've got guidance and direction, but what's important for your clients to understand is this is not over. This is just getting us through until next year.
Hi, this is Kris from The Apartment Dealer. Welcome back to The Apartment Dealer Show. This is where we bring you the information, the resources, and the network of professionals that will work alongside you in the building of your financial legacy through multifamily investments. Today, we're going to dig right into AB 3088. It's the state's newest move to give relief to tenants while putting the burden on the back of the landlords. And so we're going to dissect this law, and no one better than to help us do so. We have Mr. Mike Brennan of the Brennan Law Firm with us today. Mike practices within the San Gabriel Valley, really is a household name when it comes to tenant evictions here locally. But he's gonna, again, help us break down what's also called the Tenant Relief Act of 2020, so that you as a landlord now know at least how to get some firm footing. What do you do with non-paying tenants? How do you address tenants that have not paid during this whole pandemic issue? What can you do between now and the end of the year? Mike, thank you for being with us today.
Well, you're very welcome, and thank you for asking me to join you.
So there's several components to this, and of course we don't have time to chunk down every line and verse, but we're gonna, we want the viewers to be able to walk away at least with the major moving parts, so that they at least know when they contact your office what information they need, what are they allowed to do, not do, how do they interact with tenants who may not pay from here to the end of the year or have not been paying, since the pandemic started. So let's start there. From the overview that I gave the bill, it seems like they're breaking this into two sections. Those tenants that didn't pay from March till August, and then from now till January 31st of next year. And tell me a little bit about that. Do you address those two type of tenants differently? What does that mean?
Well, you said it accurately. What they're doing is they're breaking the tenants, or they're breaking it into two time periods, really. One is called the protected time period, and one is called the transitional time period. Very important to understand the difference, because you get significantly different remedies with each period. So the protected time period is the time period between March 1st of 2020 and August 31st of 2020. So that was just a couple days ago. During the people who did not pay rent during that period may not be evicted for that non-payment of rent. Now that's a little confusing in this law, because the law itself has what appears to me to be some contradictory language. It specifically lays out that they can't be found guilty of unlawful detainer, but it also states that if they don't comply with the notice to pay rent or quit, that they could lose their protections. But the interesting thing is, even though you are required to serve a 15-day notice to pay rent or quit, and we'll talk about the 15-day in a little bit, later on in the law, it specifically states that they can't be found guilty for unlawful detainer, but they can be sued in small claims court for the back rent that's owed. So what it looks like to me is that the law is taking all of the rent that accrued in that protected period, and it's converting it into, for lack of a better phrase right now, basically consumer debt. Mm-hmm. So you will be able to sue them in small claims court. The small claims court rules have been adjusted so that there is no longer a limit on the amount that you're allowed to seek in small claims court if you are seeking unpaid rent during that period. And there's no longer a limit as to the number of cases that a landlord can bring in small claims court. It is interesting, though, that you cannot file the small claims action until February 1st of 2021. So they're giving the tenants basically another 6 months on that first 6 months of the pandemic before the landlord can really do anything. And again, there is this confusing language because the law specifically talks about serving them a pay or quit, and it even talks about the notice expiring and bringing an action, but then later on it says that they cannot be found guilty of unlawful detainer. So I'm trying to work my way through that. And as always, I'll tell your clients, we're in uncharted territory right now in landlord-tenant law. There's no case law for us to fall back on and say, well, the courts should rule this way because we've never been here before. So that's the first period. That's the
if I could jump in just 1 second, because I know we're dividing it. So for our viewers, okay, good news is, at least for the vast majority of people we're speaking with, landlords in the area, we did a poll. They're collecting, say, 95% or better of their rents, the vast majority. But there are some that haven't fared as well. So if they had a tenant who didn't pay any sum of rent between effectively March and August, the only way to collect that rent is February of next year in small claims court. So automatically, many of these landlords are telling them, well, good luck trying to track down those monies. You might as well almost say goodbye, because not many of the tenants have much to their name or have a way to pay the bad debt. Basically, it's not going to be collected in the old days like you would have in eviction court. It's just small claims and see if you can retrieve it that way.
So yes, a lot of what you said is accurate. There's a couple caveats I would add to it. One, even if you're like you said, 95% of people are collecting on the residential, so that's the good news. Of the 5% that aren't collecting, or the 5% of tenants that aren't paying, many of them, it's legitimate. They lost their job. The COVID debt is legitimate. They really weren't able to do it. And even if they were to move, and you can't find them, there's still a way to pursue them in small claims court. And we could talk about that if your clients are interested in doing that. They can call my office. I'll walk through them, how you do that, even if you can't find the tenant, to serve them the notice. And I think it's an opportunity here, or at least you have to turn it into an opportunity. And what I mean by that is, if for those 5% of tenants that were legitimately unable to pay, or whatever percentage of the 5% that aren't paying that were legitimately unable to pay, I think if your landlord or if your clients were to go to them now and say, hey, look, the law, yes, it's true, I can't evict you for unlawful detainer at the moment, but I'm still going to serve you the notice, and you still have to follow the regulations in the law within the 15-day period. But maybe this is an opportunity for you to, if you legitimately can't afford the rent, maybe this is a legitimate opportunity for us to enter into some agreement where you agree to vacate and I agree to walk away from either a portion of the rent or maybe even the entire amount if you can vacate quickly, and we put that into a written agreement. So for that small percentage of tenants who aren't paying right now, the moratoriums have really prevented the landlords from doing anything about it. But those moratoriums are about to go away. And when they go away, like I said, it might be a great opportunity for the landlords to approach that tenant in a compassionate way, or at least present it in a compassionate way, and say, this is your opportunity. Consider it a gift, or a portion of it a gift. Let's work something out. Obviously, you can't pay, so maybe it's time for you to move on.
When can you said that it's almost time where we can have those conversations? If it's a local landlord, San Gabriel Valley, LA County, when can they have that conversation with the tenant?
One of the subtle nuances to this law is that it went into effect retroactively as of August 19th, but there are local moratoriums that are still in place. And those moratoriums, some of them specifically prohibit landlords from serving notices until one of two things happens. Either the moratorium is repealed or expires, or the state of emergency is repealed. Let's not even talk about the state of emergency, because that's not going to happen anytime soon. But the governor's executive order that he signed that gave the cities the right to draft and create these ordinances in the first place, that is set to expire September 30th. And many of the ordinances are tracked on that same date. So they are going to expire on September 30th as well. So for your clients, and again, we talked about this last time I was on, what they have to really do right now, before they serve any notices, they have to look at their local ordinance and find out, does that ordinance prohibit them from serving notices? Because some of them do. Like, I believe it's Santa Monica prohibits you from serving a notice that's not in good faith. And in good faith, they mean if you have to believe that you have to have a good faith belief that the tenant really wasn't affected by COVID. And I don't know how a landlord is going to develop that good faith belief. There are some landlords that have presented evidence to me, and I said, hey, I think you're okay. But for the majority, unless you have that good faith belief that they're really scamming the system, the ordinance prohibits serving that notice. And so they are not allowed to serve that notice until the moratorium expires, which will be September 30th. Then October 1st, they can begin serving their notices.
So let's then move to the second time frame, if you will, the September to January 31st component.
That's the transition period.
Yeah, so the tenant doesn't pay during this period. How do we proceed?